Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
Red and blue lights explode in your rearview mirror. Your stomach drops. Your hands tighten on the steering wheel, your mind racing. What did I do? Was I speeding? Did I run that yellow light? The officer approaches, a silhouette against the blinding headlights. A tap on the window. You roll it down. And then comes the question. The simple, disarming question that has sealed the fate of thousands of people. Do you know why I pulled you over? What you say next, in this single moment, can set in motion a chain of events that could drastically alter the course of your life. And the terrifying truth is, most of us have no idea what to do. We think we know. We've all seen hundreds of hours of cop shows and courtroom dramas. We think we understand the game. But what television shows you is a highlight reel, a fiction designed for drama. The reality is a complex, high-stakes system with very specific rules, and misunderstanding those rules can cost you your time, your money, and your freedom. This is why you're here. Because you know there's a gap between what you see on TV and how things really work. Over the next 10 parts, we are going to close that gap. We are going to pull back the curtain on the two most important players you might ever encounter in the American justice system: the police officer and the lawyer. This isn't about good guys versus bad guys. It's about understanding their jobs, their motivations, and their playbooks. By the end of this, you will understand the fundamental, opposing forces that define our legal landscape. You'll learn not just what your rights are, but the strategy behind when and how to use them. You will understand what an officer is looking for during an interaction, what a lawyer is listening for, and how to navigate the space between them to protect yourself. This is your masterclass in the real rules of the game. So let's start with the first person you meet, the police officer. Forget everything you've seen in movies. The officer walking up to your car is not your friend. They are not a counselor. They are not there to hear your side of the story and make a fair judgment on the spot. They are a professional fact gatherer for the state. Let me say that again because it is the single most important concept to grasp. They are gathering facts for their employer, the government. Their primary mission is to enforce the law, investigate potential crimes, and collect evidence that can be used by a prosecutor to build a case. They are the tip of the spear for the prosecution. Their job is not to determine your guilt or innocence. That happens much later, in a courtroom. Their job is to find grounds to suspect a crime has been committed, and to document everything that supports that suspicion. To do this, they operate on a standard called probable cause. You hear this term thrown around all the time, but what does it actually mean? Probable cause is not proof beyond a reasonable doubt. It's not even a 50-50 chance. It's simply a reasonable basis for believing that a crime may have been committed. Think of it like this. A firefighter doesn't need to see the flames to believe there's a fire. The smell of smoke, a heat signature, an alarm going off, that's their probable cause to break down the door and investigate. Similarly, an officer doesn't need to see you commit a crime. The smell of alcohol on your breath, a bag of white powder on your passenger seat, or a story that just doesn't add up, that can be their probable cause to move to the next level of investigation, whether it's a search, a sobriety test, or an arrest. Because their goal is to gather these facts, police officers are highly trained in the art of conversation and observation. Every question they ask is designed to elicit a response. Every observation they make is being mentally filed away. When an officer asks, "Do you know why I pulled you over?" it's not because they're curious. It's a brilliant investigative technique. If you say, "Was I speeding?" you've just admitted to one potential violation. If you say, "Is it about that broken taillight?" you've admitted to another. If you start rambling and apologizing, you might accidentally admit to something far more serious. "I'm so sorry, officer, I'm just so stressed. I only had a couple of beers tonight and I'm trying to get home." Boom. You've just given them probable cause to start a DUI investigation. You voluntarily handed them the smoke they were looking for. This brings us to the most dangerous misconception people have when dealing with law enforcement. The belief that if I'm innocent, I have nothing to hide, so I should just cooperate and explain everything. This line of thinking, while understandable, is a trap. The problem is, you don't know what the officer is investigating. You don't know what information they already have. You might be trying to explain why you were driving erratically, not realizing they're actually investigating a robbery that happened 2 blocks away where the suspect's car matched yours. Your innocent, nervous explanations about being lost or arguing with your spouse might sound, to an officer with a different set of facts, like a fabricated alibi. Your innocent statements can be twisted, misremembered, or taken out of context. You are trying to have a conversation. They are conducting an investigation. You are playing checkers. They are playing chess. And in this game of chess, the officer has a move that most citizens find absolutely shocking. They are legally allowed to lie to you. That's right. The Supreme Court has repeatedly affirmed that police can use deception during an investigation to get a confession or information. They can tell you your friend in the other room already confessed and blamed you. They can tell you they have your fingerprints on a weapon when they don't. They can tell you they have a witness who saw you do it. They can say, "Look, we know you didn't mean for it to happen. Just tell us your side of the story and we can help you out." The prosecutor will go easy on you if you cooperate. This is a tactic. They cannot promise leniency, only a prosecutor can do that. Their job is to get information that can be used against you. They are using psychological tactics, honed through years of training and experience, to get you to lower your guard and talk. So, if the police officer is a fact gatherer for the state, trained to investigate and build a case against you, who is on your side? Who is the counterbalance to this immense state power? That's where the lawyer comes in. A defense attorney's role is the polar opposite of the police officers. Their sole sworn duty is to you, the individual. They are not a fact gatherer for the state. They are a shield against it. Their job is not to determine what happened. Their job is to defend their client, and to force the state to prove its case beyond a reasonable doubt. While the police officer is looking for the smoke of probable cause, your lawyer is there to ensure the prosecution brings the fire of actual proof. They are your advocate, your strategist, and your constitutional guardian in the face of the entire apparatus of government. Their loyalty is not to the truth in a general sense. Their ethical and legal loyalty is 100% to their client. And understanding this fundamental opposition, the state's investigator versus your personal defender, is the key to unlocking the entire justice system. Let's pry that lock open. To truly grasp this conflict, we have to dissect the role of the police officer, not as they appear on TV, but as they function in reality. Forget the idea of a neutral arbiter of truth. A police officer on a case is a builder. Their job is to gather raw materials, witness statements, physical evidence, confessions, and construct a case. A strong case. A case that will stand up in court and lead to a conviction. Their goal, mandated by the state they work for, is to close the case by identifying a suspect and providing the prosecutor with enough evidence to prove guilt beyond a reasonable doubt. This isn't a criticism. It's a job description. But it's a job description that contains a powerful, inherent bias. It's called confirmation bias. Once an officer or a detective has a theory about who committed a crime, human nature dictates that they will start looking for evidence that confirms that theory. They'll interpret ambiguous facts in a way that supports their narrative. Evidence that contradicts their theory might be overlooked, dismissed as irrelevant, or seen as a deliberate deception by the suspect. They are not looking for the whole truth, with all its messy contradictions. They are looking for the prosecutorial truth, the cleanest, most direct story that leads from crime to suspect to conviction. Their primary tool for building this story isn't a magnifying glass. It's conversation. It's the interrogation. And this is where the vast majority of people get into trouble. Police are masters of human psychology. They are trained to build rapport, to make you feel comfortable, to make you feel like they are on your side. They might offer you a coffee, speak in a friendly tone, and say things like, "We just want to clear this up," or "Help me understand what happened," or the classic, "If you're innocent, you've got nothing to hide." Every single one of those phrases is a key designed to unlock your mouth, because they know something most of us don't. Your own words are the most powerful weapon that can be used against you. Let's create a scenario. Meet Mark. Mark is a 28-year-old graphic designer. One Tuesday afternoon, he leaves his office to grab a late lunch. He's walking down the street, headphones on, listening to a podcast. A block away, a convenience store was just robbed. The suspect is described as a white male in his late 20s, wearing a dark hoodie and jeans. Mark is wearing a dark hoodie and jeans. Two police officers stop him. The first interaction is completely non-threatening. Excuse me, sir. Did you see anyone running from that direction? Mark, wanting to be a good citizen, pulls off his headphones. No, sorry, officer, I was in my own world. The officers exchange a glance. All right. Mind if we ask you a few questions? We're just trying to piece together what happened. Mark agrees. Why wouldn't he? He's innocent. He has nothing to hide. This is the first and most critical mistake. The questions start broad. Where are you coming from? Where are you headed? Mark answers honestly. Coming from my office on Elm Street, heading to the deli on Main. Then the questions get a little more specific. What time did you leave your office? Mark hesitates. He's not sure. Around 2:15, I think. In reality, he checked an email right before he left, and the timestamp was 2:23 p.m. It's an innocent mistake, a guess, but he's just given a piece of information. Fact. One officer stays with Mark, making small talk, keeping him comfortable. Man, crazy world, huh? Can't even grab a sandwich. The other officer is on his radio, relaying information. They find out the robbery happened at 2:25 p.m. The suspect was seen running down Elm Street at 2:27 p.m. Mark's innocent guess of 2:15 suddenly looks suspicious. It gives him plenty of time to have been near the store. The friendly officer now changes his tone just slightly. It's less like a chat and more like an interview. So you're sure it was 2:15? Take a second to think. It's important. Mark starts to feel a knot in his stomach. He's being scrutinized. He gets defensive. Look, I don't know, maybe it was 2:20. I didn't look at a clock. I just left work. His defensiveness is noted. To the officer, an innocent person is calm and helpful. A guilty person gets nervous and defensive. They don't see a regular guy flustered by a sudden accusation. They see a potential suspect exhibiting classic signs of deception. Just relax, Mark. We're just trying to eliminate you from our inquiry. If you've got nothing to hide, just work with us. Why don't you come down to the station where we can talk more comfortably? This isn't a request. Mark feels like he has to go. He gets in the back of the patrol car. The door closes with a solid, definitive thud. He's not under arrest, they tell him. He's just assisting with an inquiry. But he is not free to leave. At the station, he's put in a small windowless room. The friendly officer is gone. Now it's two different detectives. This is the good cop, bad cop routine. A tactic so old it's a cliché, yet it remains brutally effective. The bad cop comes in hot. Don't lie to us, Mark. We know you were there. We have a witness who saw you. Your timeline is a mess. Just make it easy on yourself. Mark is shocked. A witness? There is no witness. This is a common and perfectly legal police tactic. They are allowed to lie to you during an interrogation. They can lie about evidence. They can lie about witnesses. They can lie about what other people have said. Mark denies everything, his voice trembling. I didn't do anything. I was just getting lunch. The bad cop storms out, slamming the door. Now the good cop comes in. He sighs, sits down, and leans forward conspiratorially. Listen, my partner, he's a hothead. But he's not wrong. This doesn't look good for you. I know you're not a bad guy. Maybe you were in the wrong place. Maybe you just needed some money. I get it. Times are tough. Just tell me what happened and I can help you. I can talk to the DA, tell them you cooperated. Maybe we can get this sorted out so you go home today. But if you keep lying, my hands are tied. You'll be facing serious time. This is the siren song of the interrogation room. It's an offer of a life raft to a drowning man. Mark is scared, confused, and utterly alone. He's been there for hours. He just wants it to end. He starts thinking, maybe if I just give them something, they'll let me go. Maybe I did see something I don't remember. He starts to talk. Okay, look, maybe I saw a guy running. He had a hoodie on. He's trying to be helpful. He's inventing a memory to satisfy them. But the detectives pounce. What did he look like? What was he wearing? Which way did he go? Every detail Mark invents, every guess he makes, is another shovel of dirt on his own grave. He gets a detail wrong that contradicts a known fact. Now he's not just a suspect, he's a liar. His attempts to cooperate have been twisted into evidence of his deception and consciousness of guilt. By the end of the night, Mark has signed a statement full of inconsistencies and half-truths born of fear and exhaustion. He hasn't confessed to the robbery, but he has destroyed his own credibility. He has given the prosecutor a mountain of ammunition to use against him. He walked into that encounter as an innocent bystander and walked out as the prime suspect, all because he thought the police were there to find the truth. He didn't understand they were there to build a case, and he was their easiest source of raw material. This is the fundamental power imbalance. The police have the training, the authority, and the full weight of the state behind them. You have your words. And in that room, your words are not your shield. They are the bricks they will use to build your prison. Invoking your right to remain silent isn't an admission of guilt. It's an admission that you understand the rules of the game. It's recognizing that you are a civilian who has been pulled into a professional arena with a player whose sole objective is to score against you. You are not required to help them. The Fifth Amendment isn't a technicality for criminals. It's a foundational shield for the innocent, protecting them from the immense coercive power of the state. Mark thought his words would set him free. Instead, they were forging the bars of his own cell. And the police officer holding the hammer wasn't his enemy. He was just doing his job. So what happens when you finally get that one person who is on your side? What does a lawyer actually do the moment they get that call? The answer is a masterclass in strategic defense that begins before they even meet you. The moment that call comes in, often in the dead of night, a clock starts ticking. But it's not the one on the wall. It's a strategic clock, and every second that passes is a second the state is using to solidify its case against you. The defense attorney's first move isn't to jump in their car. It's to pick up the phone and forge the first piece of armor for their client. Their first call is to the police station, or the county jail where their new client is being held. And this call is not a polite inquiry. It is a declaration of legal war. The conversation is brief, professional, and surgically precise. The lawyer identifies themselves, states that they represent the person in custody, and asks to confirm their presence. But then comes the most critical sentence in the entire early stage of a criminal case. The lawyer will state, in no uncertain terms, something like this: I am instructing my client to invoke their Fifth Amendment right to remain silent and their Sixth Amendment right to an attorney. Do not ask them any more questions. Do not speak to them about the case. I will be there as soon as possible. That single statement is a legal force field. It slams the door shut on the police interrogation that was likely already underway or about to begin. Remember the officer's goal from earlier? To get a statement, to get a confession, to get something they can use. That lawyer's phone call is a direct countermeasure. It's the legal equivalent of cutting the bomb wire with 1 second left on the timer. Because until that moment, a person sitting in a cold, intimidating room, scared and confused, is an open book. They might think they can talk their way out of it. They might think, if I just explain my side, they'll understand. This is almost never true. Every word they say is a potential brick in the wall of the prison cell the prosecutor wants to build for them. The lawyer's first action is to stop them from handing the prosecution free building materials. With that shield in place, the race continues. The lawyer now has a precious window of time. They're not just coming to see their client. They're launching an information-gathering blitzkrieg. They will immediately try to get their hands on the initial police report, the probable cause affidavit. This is the document where the arresting officer lays out the bare-bones story of why they believe a crime was committed and why they arrested this specific person. For a defense attorney, this document is gold. It's the prosecution's opening move, laid bare on the table. They're not reading it like a story, they're dissecting it. They're looking for cracks, for inconsistencies, for leaps in logic. Did the officer really have a legal reason to pull that car over? Does the witness statement sound credible or coached? Is the timeline physically possible? The lawyer is looking for the shaky foundation upon which the entire case is built, and they're doing it within hours of the arrest. Then comes the first meeting. Forget what you see on TV. It's not a cozy office with leather chairs. It's a small, sterile, often windowless room in a jail. There's a palpable sense of fear and despair in the air. The client is likely wearing a jail-issued uniform, stripped of their identity, their confidence, their freedom. This is where the lawyer's job becomes part psychologist, part strategist, and part the only friend you have in the world. The first thing a good lawyer does is establish trust. They look their client in the eye and say, I am on your side, no matter what. My job is not to judge you. My job is to defend you. You and I are a team, and everyone else in this process is on the other team. This is a profound moment. For the first time since the flashing lights appeared in the rearview mirror, the person is not alone. After establishing that bond, the lawyer delivers the second most important instruction of the entire case. Do not talk about this case with anyone but me. I mean anyone. They'll lean in and explain. The person sleeping in the bunk next to you? They might be looking to trade information for a better deal on their own case. The phone calls you make to your family? They are being recorded. Every word. The letters you write? They can be read. From this moment on, the only safe place to talk about what happened is in a room with me. This advice has saved countless people from convicting themselves. The temptation to confide in a cellmate or vent to a loved one on the phone is immense, but it's a trap. The lawyer's job is to make their client see the hidden dangers of a system designed to extract information at every turn. Only then, once the shield is up and the warnings have been given, does the lawyer ask the million-dollar question. Tell me everything. Start from the beginning. Don't leave anything out, good or bad. I can't defend you against a secret. And as the client tells their story, the lawyer is not just a passive listener. They are an active investigator, a legal archaeologist digging for facts that can save their client's future. Their questions are not random. Each one is aimed at a potential weakness in the state's case. When the officer approached your car, what were the very first words he said to you? The lawyer is listening for the legal justification for the traffic stop. If the cop didn't have a valid reason, everything that follows the search, the arrest, could be thrown out of court. It's called fruit of the poisonous tree. Did they ask for permission to search your car or your person? What were your exact words? Many people don't realize they can say no. If they said yes, that's consent. But if the police search without consent and without a warrant, they've just stumbled into a major Fourth Amendment violation. At what point did they read you your rights? Was it before or after you started answering questions about the incident? This is the Miranda warning. If you're in custody and they're interrogating you, they have to read you those rights. If they don't, any statement you make can be suppressed, meaning the jury will never hear it. Who else was there? Did you see anyone else? Get me names, descriptions, anything you can remember. The police talk to the witnesses who support their narrative. The lawyer is now searching for the witnesses the police didn't want to talk to, the ones who saw something different, something that helps the defense. This process is a meticulous deconstruction of the state's version of events. While the police were collecting evidence of guilt, the lawyer is now collecting evidence of innocence, or, just as importantly, evidence of doubt. Because in the American justice system, doubt is all you need. The lawyer is building a counter-narrative. They are piecing together a different story from the same set of facts. A story that shows their client in a different light. A story that presents an alternative explanation. And finally, in that first meeting, the lawyer sets expectations. They don't promise a dismissal or a not guilty verdict. The system is too unpredictable for that. Instead, they provide a roadmap. They explain what's coming next. The arraignment, the bail hearing, the discovery process. They turn a terrifying unknown monster into a series of manageable steps. They replace fear with a plan. So while the police officer's job ended with the clang of a jail cell door, the lawyer's job has just begun. They have established a perimeter, gathered initial intelligence, and started building a fortress of reasonable doubt. They have transformed their client from a passive subject of a state investigation into an active participant in their own defense. But the client is still behind bars. The immediate, most pressing battle is about to be fought. It's not about guilt or innocence yet. It's about freedom itself. The next step is the bail hearing, a high-stakes legal argument that will determine whether the client fights their case from a jail cell or from their own home. And it's a fight where the lawyer's skill can make all the difference. The courtroom is cold, impersonal, and smells faintly of old paper and nervous sweat. This isn't the grand wood panel chamber you see in movies. It's a functional, often cramped room where life-altering decisions are made in minutes. The judge, sitting elevated, has a stack of files, each one representing a person whose immediate future they hold in their hands. Our defendant, now in a standard-issue jumpsuit, looks small and out of place. This is the arena for the bail hearing. The prosecutor rises. They are the voice of the state, and at this stage, the voice of the police investigation. In their hand is the police report, the culmination of the officer's work on the street and at the station. To the prosecutor, this document is the objective truth. It's a snapshot of a crime, and the defendant is the person captured in that frame. They begin to speak, their voice calm and authoritative. They lay out the charges, reading directly from the report. The language is stark, clinical, and damning. They don't say, "The officer alleges." They say, "The defendant did." The prosecutor's goal is simple. Convince the judge that this person is either a danger to the community or a flight risk, or both. They will use the most inflammatory details from the police report to paint their picture. They'll emphasize the alleged violence of the crime, the potential weapons involved, the fear of the alleged victim. They'll highlight any prior criminal record, no matter how minor or old, framing it as a pattern of behavior. Your Honor, they might say, the defendant has demonstrated a clear disregard for the law. Releasing them back into the community would pose an unacceptable risk. Then comes the argument about flight risk. The defendant has few ties to this community, they might argue, even if it's not entirely true. The severity of these charges provides a powerful incentive to flee the jurisdiction. We request bail be set at $200,000, or in more serious cases, we ask that the defendant be remanded without bail. That phrase, remanded without bail, is one of the most chilling in the legal system. It means the presumption of innocence is, for all practical purposes, suspended. The defendant will be locked in a cage until their trial is over, a process that can take months, even years. The police made the arrest, but it's the prosecutor, using that arrest report, who is now trying to cage the person indefinitely. Now the defense lawyer stands. Their job is to tear down that entire narrative. They have to do it quickly, effectively, and with only the information they've managed to gather in the last 24 to 48 hours. They don't have the state's resources. They have a terrified client and a frantic family. Their first move is to attack the foundation of the prosecutor's argument, the police report itself. They'll point out its limitations. Your Honor, the state's entire argument is based on a few paragraphs written by an officer in the immediate aftermath of a chaotic event. These are allegations, not facts. They have not been tested, cross-examined, or proven. They will de-escalate the prosecutor's inflammatory language. Where the prosecutor saw a violent rampage, the lawyer might describe a dispute that got out of hand. Where the prosecutor points to a dangerous weapon, the lawyer might clarify it was a legally owned tool with a plausible, non-violent explanation for its presence. They are reframing the narrative, introducing doubt and context where the prosecutor presented only a stark, negative conclusion. But challenging the state's story is only half the battle. The lawyer's most important job is to do the opposite of what the prosecutor did. Instead of turning a person into a file, they have to turn a file back into a person. They present a different kind of evidence. Not evidence of the crime, but evidence of a life. They call it presenting community ties. They'll say, Your Honor, my client, Mr. Smith, is not a flight risk. He has lived in this city his entire life. His mother is sitting in the back of this courtroom. His 2 young children are waiting for him at home. He's been employed as a mechanic at the same local garage for the last 7 years. His boss, Mr. Jones, has provided a letter, which I'm submitting to the court, stating that his job is waiting for him. They hand the judge letters from family, from a pastor, from a little league coach. They provide pay stubs and lease agreements. Each document is a thread, and the lawyer weaves them together to create a tapestry of a life rooted in the community. They are demonstrating that this person has everything to lose by running. Their entire world is here. Fleeing wouldn't be an escape. It would be a self-imposed exile from everyone and everything they care about. Finally, a skilled lawyer doesn't just ask for release. They offer solutions. They anticipate the judge's concerns. Your Honor, we understand the court's concern for public safety. To that end, my client is willing to agree to any number of conditions. He will submit to electronic monitoring. He will check in weekly with a court officer. He will surrender his passport. He will stay 1,000 yards away from the complaining witness. We are not asking for a free pass. We are asking for a chance for him to fight this case as a free man. A man who is presumed innocent under our Constitution. This is a critical point. The 8th Amendment to the Constitution prohibits excessive bail. The purpose of bail isn't to punish someone before they're convicted. It's simply to ensure they show up for court. The lawyer is reminding the judge of this principle, framing the argument not as a plea for mercy, but as a demand for a constitutional right. The judge listens to both sides. They look at the police report. They look at the letters from the family. They look at the defendant. And then they make a decision. Sometimes they side with the prosecutor, and the bail is set impossibly high. The sound of the gavel feels like a hammer blow, and the defendant is led away. Their fight for freedom now infinitely harder. But often, a good lawyer's argument prevails. The judge might say, bail is set at $10,000, with the conditions proposed by the defense. In that moment, the entire dynamic of the case shifts. The client won't be going back to a cell. They can go home, hug their family, go back to work, and most importantly, they can sit side by side with their lawyer to prepare their defense. They can help review evidence, identify witnesses, and make critical decisions about their own case. The difference is night and day. A defendant fighting from a jail cell is at an immense disadvantage. Their isolated communication with their lawyer is difficult, and the psychological pressure to just plead guilty to anything to get out is enormous. Many innocent people have taken plea deals for this very reason. Securing release on bail isn't just a win for the client's comfort. It's a massive strategic victory in the war for their liberty. The lawyer hasn't proven their client's innocence, not yet, but they have secured the most crucial resource of all, the freedom to fight. With the bail hearing concluded, one chapter closes and another, far more complex, begins. The initial clash is over. Now the real investigation starts not on the street but in the files. The lawyer knows the police report is just the tip of the iceberg. To truly defend their client, they need to see everything the police and the prosecutor have, every note, every recording, every piece of evidence. This next phase is called discovery, and it's where the lawyer officially goes on the offensive, demanding the state reveal its hand. And what they uncover can change everything. The moment a defense lawyer receives the discovery package, the entire dynamic of the case shifts. It's like being handed the opposing team's playbook, their secret signals, and the game film from every practice they've ever had. This isn't a courtesy. It's a constitutional right. Under a landmark case called Brady v. Maryland, prosecutors are legally and ethically bound to turn over all evidence, especially anything that might help the defendant, what's known as exculpatory evidence. Hiding evidence that could prove someone's innocence isn't just a mistake. It's a catastrophic violation that can get a conviction overturned and a prosecutor disbarred. So the lawyer sends a formal request, and what comes back is rarely a neat, organized binder. It's a digital avalanche. Gigabytes, sometimes terabytes of data. Every single police report from every officer involved. Scanned handwritten notes from the field. Witness statements, audio recordings of interviews, 911 calls. Crime scene photos from every conceivable angle. Lab reports on fingerprints, DNA, ballistics. And the crown jewel of modern discovery. Hours upon hours of body camera and dashcam footage. A common misconception is that a lawyer reads the police report to find out what happened. That's not it at all. A lawyer reads the police report to find out what the police want to prove happened. It is the official story, the clean narrative, the version of events that leads to one, and only one conclusion: guilt. The lawyer's job is to treat that report not as a statement of fact, but as a hypothesis to be tested, attacked, and dismantled. They are not a passive reader. They are an aggressive forensic analyst of language. Let's imagine a simple assault case. The police report, written by Officer Miller, reads, "Upon arrival, I observed the victim with a laceration above his right eye. The victim stated that the suspect, Mr. Jones, struck him without provocation. A witness, Ms. Davis, corroborated the victim's account. Mr. Jones was belligerent and uncooperative upon arrest. Open and shut, right? Not for a lawyer." The lawyer prints out that report and attacks it with a red pen. Laceration above his right eye. The lawyer immediately pulls up the crime scene photos. How big is the cut? Does it look like it came from a fist? Or could it be from falling and hitting the corner of a table? They look for photos of the suspect's hands. Are his knuckles bruised or swollen? If not, why not? The report doesn't mention it. That's the first question mark. Struck him without provocation. This is a conclusion, not a fact. The lawyer immediately flags this. What did the officer do to investigate the possibility of provocation? Did he interview anyone else? Did he ask the victim what they were arguing about? The absence of that information in the report is deafening. The lawyer then turns to the witness statement from Ms. Davis. Ms. Davis corroborated the victim's account. Corroborated how? Did she just say, "Yeah, what he said"? Or did she give her own independent version of events? The lawyer pulls the audio file of her interview. On the recording, Ms. Davis sounds hesitant. She says, "It all happened so fast. I think I saw him swing." "I think I saw him swing" is a universe away from the report's clean statement that she corroborated the account. The officer summarized her uncertainty into a concrete fact that supported his narrative. That's not just an inconsistency. It's a potential deception. Mr. Jones was belligerent and uncooperative. This is the oldest trick in the book, painting the suspect as an aggressive bad guy to justify the arrest. But now we have the body cam. The lawyer scrubs through the footage and what they see is gold. Mr. Jones isn't belligerent. He's scared. He's repeatedly asking, "What's going on? Why are you arresting me?" He's not physically resisting. He's pulling his arm away because the handcuffs are being put on too tight, and he's saying, "Ow, that hurts." The officer's subjective description of belligerent is completely shattered by the objective reality of the video. In a single hour of work, the lawyer has transformed the case. The definitive medical evidence is questionable. The unprovoked nature of the attack is an uninvestigated assumption. The corroborating witness is actually uncertain. And the suspect's belligerent behavior is a gross mischaracterization. The case is no longer a solid brick wall. It's a crumbling facade with light pouring through the cracks. This process is repeated for every single piece of evidence. The lawyer scrutinizes the chain of custody report for the DNA sample. Who collected it? How was it sealed? Who transported it? Was the evidence locker it was stored in properly secured? Any gap, any unsigned form, any unexplained delay can be grounds to get that evidence thrown out of court. They analyze the 911 call. Does the victim sound terrified? Or does he sound angry and vengeful? Does he mention a weapon that was never found? This is the fundamental difference in their roles. The police officer is a builder. They arrive at a chaotic scene and their job is to collect pieces of information, witness statements, physical evidence, and assemble them into a coherent structure, a case. They are looking for evidence that fits their theory of the crime. The defense lawyer is a demolition expert. They are given that finished structure, and their job is to find the single load-bearing wall that was built on a weak foundation. They aren't looking for what fits. They are hunting for what doesn't. The witness who saw a green car when everyone else saw a blue one. The timestamp on the security footage that shows the suspect was a mile away 2 minutes before the crime was committed. The lab report that identifies a second person's DNA under the victim's fingernails that the police never bothered to identify. They are looking for the story the evidence tells that the police chose to ignore. Often, the most powerful evidence for the defense comes directly from the prosecution's own files. It's the body cam footage that contradicts the sworn police report. It's the initial interview where the star witness says, "I'm not sure," before their memory magically improves a week later. It's the GPS data from the suspect's phone that the police collected to prove he was at the scene, but which the lawyer uses to prove he was stuck in traffic on the other side of town. Every piece of paper, every video file, every audio recording is a potential weapon. The lawyer isn't just looking for a gotcha moment. They are methodically gathering leverage. Each inconsistency, each contradiction, each piece of sloppy police work becomes a bargaining chip. It's ammunition to be used in negotiations with the prosecutor, to cross-examine a witness on the stand, or to argue before a judge that the entire case is built on a foundation of sand. The police investigation might be over, but the lawyer's investigation has just begun. They are now armed not with speculation or theory, but with the state's own words, their own images, and their own data. The lawyer now holds a powerful weapon. The state's own evidence turned against itself. But finding a crack in the case is one thing. Breaking it wide open is another. The next step is to take this newfound leverage and force the prosecutor's hand in a high-stakes negotiation that happens far away from any courtroom. This hidden world is where the vast majority of American justice is actually decided. Forget what you see on TV. The dramatic courtroom showdowns, the surprise witnesses, the "I object." That's the exception. The rule, the engine that keeps the entire system from grinding to a halt, is the plea bargain. Over 95% of all criminal convictions in the United States come not from a jury verdict, but from a deal struck between a prosecutor and a defense attorney. This isn't a flaw in the system. It is the system. And in this arena, the lawyer isn't a performer. They're a negotiator, a strategist, a poker player with someone else's life as the stakes. The prosecutor holds most of the cards. They represent the full power and resources of the state. They have police reports, lab results, and the ability to file charges that carry terrifyingly long mandatory minimum sentences. Their primary goal is a conviction. Trial is a gamble. It costs time, money, and there's always a chance, no matter how small, that a jury will acquit. Plea deal is a sure thing. It's a win on the scoreboard, a case closed, a statistic that helps them keep their job and advance their career. So they come to the table with an immense amount of leverage. The defense attorney, on the other hand, comes to the table with one primary weapon: doubt. Every inconsistency they found in the police work, every constitutional violation, every piece of shaky evidence, that's their ammunition. The goal isn't necessarily to prove their client is innocent. In this room, the goal is to convince the prosecutor that a trial is a risk they don't want to take. It's to show them that their slam dunk case is actually full of holes, and that putting it in front of 12 random citizens is a roll of the dice. The negotiation begins. It's rarely in a formal setting. It's a phone call. It's a hushed conversation in a courthouse hallway. The prosecutor makes the first move, often with what's called an exploding offer. It's intentionally harsh and has a short deadline, designed to create panic. Look, the prosecutor might say, your guy is looking at 20 years for armed robbery. But if he pleads guilty today, right now, I'll recommend 7. The offer is off the table tomorrow, and we proceed to trial on the full charge. A novice lawyer might flinch. They might rush to their client with the offer, presenting it as a massive discount on a prison sentence. But a seasoned defense attorney knows this is just the opening gambit. They don't react to the threat. They attack the premise. 7 years, the lawyer scoffs. For what? A case built on a single eyewitness who saw a man in a hoodie from across a dark street? You and I both know that ID won't hold up under cross-examination. And let's talk about the confession. The arresting officer's body camera was mysteriously malfunctioning until the moment my client supposedly started talking. A jury is going to eat that alive. They're going to think the cop is hiding something because he is. We're not taking 7 years. We're not taking any years. We'll see you at trial. This is the art of leverage. The lawyer is taking the cracks they found in the police investigation and using them to devalue the prosecutor's case. They are painting a picture of a messy, embarrassing, and very public trial that the prosecutor could easily lose. Now the prosecutor has a decision to make. Is the defense attorney bluffing? How confident are they, really? The prosecutor reviews the file again. They know the eyewitness is weak. They know the body camera issue is a problem. Losing a high-profile robbery case is a bad look. It emboldens other defense attorneys and makes their office look incompetent. So they come back with a new offer. Okay, let's be reasonable. What if we drop the armed robbery charge down to robbery in the second degree? No firearm enhancement. The sentencing guideline is 3 to 5 years. I can recommend 3. The negotiation has shifted. The lawyer has successfully used the police officer's procedural errors to force the prosecutor to a lesser charge. But it's still not over. 3 years in prison is a lifetime. The lawyer pushes back again. It's still too high. My client has no prior record. He has a job, a family. 3 years will ruin his life over a case you can barely prove. How about a misdemeanor? Assault in the 3rd degree, time served and probation. This is the dance. A back and forth of offers and counteroffers, threats and bluffs. But beneath it all is a brutal calculation. The prosecutor is calculating the probability of winning at trial versus the certainty of a conviction on a lesser charge. The defense attorney is calculating the risk of losing at trial and getting a 20-year sentence versus the certainty of a lesser, but still life-altering punishment. And this leads to the most difficult conversation a defense lawyer ever has. They must go to their client, a person who may have been telling them from day one, I didn't do it, and lay out the cold, terrifying math of the American justice system. The lawyer has to say, listen, they are now offering a deal. If you plead guilty to this lesser crime, you will serve 1 year in county jail and then be on probation. I have to be honest with you. I believe you are innocent. I believe their case is weak, and I believe we have a very strong chance of winning if we go to trial. But I can never ever promise you what a jury will do. There is always a chance we could lose. A small chance, but it's not 0. And if we lose, the judge isn't sending you to jail for 1 year. You will go to state prison for 20. The decision has to be yours. A guaranteed 1 year for a crime you didn't commit, or the risk, however small, of losing 2 decades of your life. This is the crushing reality of plea bargaining. It creates a system where the trial becomes a punishment in itself. The sheer terror of the trial penalty, the massively longer sentence you face for exercising your constitutional right to a trial, is so immense that it forces even innocent people to plead guilty. They are not admitting guilt. They are surrendering to the odds. They are making a rational choice in an irrational system, choosing a definite, manageable loss over a potential catastrophic one. The police officer who made the initial arrest is nowhere to be found in this process. They've done their job and moved on to the next case. But their actions, every note they took, every procedure they followed or failed to follow, are the foundation upon which this entire negotiation is built. A solid, by-the-book investigation gives the prosecutor a rock-solid hand to play. A sloppy investigation, full of shortcuts and constitutional violations, gives the defense attorney the aces they need to force a better deal. Or even a dismissal. Sometimes a deal is reached. The client takes the plea, the prosecutor gets their conviction, the lawyer has mitigated the damage, and the great assembly line of justice rumbles on. But what happens when no deal can be made? What happens when the prosecutor refuses to budge from an unreasonable offer? Or more importantly, what happens when the client, staring down the barrel of a prison sentence for something they didn't do, looks their lawyer in the eye and says, "No, I won't plead guilty. Let's go to trial." Then the game changes entirely. The backroom dealing is over. The poker chips are pushed to the center of the table. The fight moves from the prosecutor's office to the most formal and high-stakes arena in the entire legal system. And the police officer, who has been a ghost in the machine up to this point, is about to be thrust directly into the spotlight, because their testimony is now the entire case. The negotiation has failed. The war is about to begin. And the battlefield is not a street corner under the flicker of neon lights. It's a quiet, wood-paneled room, sterile and silent, where the weapons are not firearms but words. This is the courtroom, and it is the defense attorney's home turf. The police officer, so confident and in command during the arrest, now walks into a foreign land where they are no longer the authority. They are simply a witness. They take the stand, raise their right hand, and swear an oath to tell the truth, the whole truth and nothing but the truth. And in that moment, the entire weight of the state's case settles squarely on their shoulders. First comes the prosecutor. This is the direct examination. It's designed to be a comfortable, structured conversation. The prosecutor is the officer's guide, their ally. The questions are open-ended, designed to let the officer tell their story in a clear, compelling narrative for the jury. "Officer, could you please state your name and badge number for the record? How long have you been a police officer? Directing your attention to the night of August 14th, where were you at approximately 11:30 p.m.? The questions are softballs designed to build credibility. The prosecutor gets the officer to recount their training, their experience, their years on the force. They are painting a picture of a competent, trustworthy public servant. Then they walk the officer through the events of the arrest step by methodical step. What did you observe, officer? And what happened next? Can you describe the defendant's demeanor for the jury? The officer recounts the story they've probably told 100 times by now, to their partner, their sergeant, in their report. They speak about the swerving vehicle, the smell of alcohol, the slurred speech, the failed sobriety tests. The prosecutor is essentially handing the officer a paintbrush and a canvas, allowing them to recreate the scene in the jury's mind. A scene where the officer is the hero and the defendant is the clear-cut lawbreaker. From the jury's perspective, it seems open and shut. This officer is professional. Their story is consistent. The case seems solid as stone. The officer feels a sense of relief. This isn't so bad. They're just telling the truth. The prosecutor finishes. "No further questions, Your Honor." And then the defense attorney stands up. The entire energy in the room shifts. The air crackles. The friendly guide is gone, replaced by a surgeon holding a scalpel, ready to dissect every word, every memory, every action the officer has just described. This is cross-examination, and its purpose is not to discover the truth. Its purpose is to destroy the prosecution's version of the truth. Its purpose is to create one single powerful thing in the minds of the jury: reasonable doubt. The defense attorney doesn't start by yelling or accusing the officer of lying. That's amateur hour. A great defense attorney starts subtly, chipping away at the edges of the officer's certainty. They begin with the things the officer can't possibly be 100% sure about. "Officer, you testified that it was approximately 11:30 p.m. Is that correct?" "Yes." "So it was dark out?" "Yes." "And you were in your patrol car about, what would you say, 50 feet behind my client's vehicle when you first observed it?" "That sounds about right." 50 feet. At night. And the street lights on that particular road, they're not very bright, are they? There are long stretches between them. "I suppose. So it's fair to say the lighting conditions were not ideal." Notice what's happening. The attorney isn't saying the officer is a liar. They're just suggesting that maybe, just maybe, what the officer thought they saw wasn't as clear as they presented it. They are turning a confident observation into a questionable perception. Next, the attorney goes after the officer's memory. And their greatest weapon is the officer's own police report. Written just hours after the incident. Officer, you just told this jury that my client said, and I quote, "I only had 2 beers. Is that your testimony today?" Yes, it is. The attorney walks slowly over to their table, picks up a document. It's the police report. Officer, I'm holding your official report, which you signed on the night of the arrest. I'd like you to read the last sentence of the 3rd paragraph for the jury. The officer takes the report. Their eyes scan the page. There's a slight hesitation. The driver stated he had a couple of drinks. The attorney lets the silence hang in the air for a moment. So, officer, on the night of the arrest, with the events fresh in your mind, you wrote that my client said he had a couple of drinks. But today, over a year later, you are telling this jury he specifically said 2 beers. Your memory of the event is somehow more specific today than it was on the very night it happened? Which one is it, officer? A couple of drinks or 2 beers? Seems like a tiny, insignificant detail. Who cares? But that's not the point. The point is to create a contradiction. The attorney has just shown the jury that the officer's testimony on the stand is different from their own official report. If he was wrong about this tiny detail, what else might he be wrong about? The seed of doubt has been planted. Now the attorney attacks the one thing police officers are supposed to hold sacred: procedure. They will have studied the department's policy manual, a document hundreds of pages long, filled with intricate rules for every possible situation. Officer, let's talk about the field sobriety tests. You administered 3 of them, correct? Yes. And for the walk-and-turn test, your departmental guidelines state that you must first ask the suspect if they have any medical conditions that would prevent them from performing the test. Isn't that right? That is the standard procedure, yes. But you didn't ask my client that question, did you, officer? We've all reviewed your body camera footage. The question is never asked. I determined he was physically able to perform the test. That's not what I asked, officer. I asked if you followed your own department's procedure. You did not, did you? Please, just a simple yes or no. The officer is trapped. No. The attorney has just scored a major point. They've shown the jury that this officer, this professional who seemed so competent a few minutes ago, cut a corner. They didn't follow their own rules. And the implication is devastating. If an officer is willing to ignore the rules during the investigation, can we trust that they gathered the evidence fairly? Can we trust their conclusions? This is the brutal reality of the courtroom. The officer's job is to react to chaotic, unpredictable situations on the street in real time. The lawyer's job is to sit in a quiet office for months and pick apart that reaction frame by frame, word by word, in slow motion. The lawyer is trying to get the officer angry, to make them defensive, to bait them into an argument. Because an angry, defensive cop looks like a less reliable witness to the jury. The officer is trained to take control, but on the stand their only power is to remain calm, to answer only the question asked, and to stick to the facts. It is a grueling mental chess match. Every word is a potential trap. The officer, who was so sure of the defendant's guilt on the night of the arrest, now sees their entire case being dismantled piece by piece, not with new evidence, but with their own words, their own report, their own procedures. They saw what they saw. They know the defendant was drunk. But what you know and what the prosecutor can prove beyond a reasonable doubt are 2 vastly different things. The lawyer isn't there to find objective truth. They are there to be the ultimate quality control for the justice system. They are stress testing the state's case. And the officer on the stand is the single point of failure. If they crack, the whole structure collapses. And as the cross-examination continues, the cracks are beginning to show. The defense attorney takes a slow step forward, their voice dropping, becoming almost conversational. It's a disarming tactic. The aggression fades, replaced by a calm, surgical precision. They're no longer attacking the officer. They're inviting him to help them understand. Officer, the lawyer begins, let's go back to the moment you initiated the traffic stop. In your report, which you wrote approximately 2 hours after the arrest, you stated the reason for the stop was a defective taillight. Is that correct? The officer, trying to regain his footing, nods. Yes. The passenger side taillight was not illuminated. The lawyer nods, as if this is perfectly reasonable. And it was this observation that gave you the legal authority to pull over my client's vehicle. That's correct. And this was at approximately 11:30 p.m. on a Tuesday night in March? Yes. The lawyer pauses, letting the silence hang in the air. Officer, are you familiar with the maintenance records for your patrol vehicle? A flicker of confusion crosses the officer's face. I do a pre-shift inspection. I'm sure you do, the lawyer says smoothly. But are you aware that on the night in question, your own patrol vehicle's dashcam system was malfunctioning and had been logged for maintenance 3 days prior? Specifically, the low-light recording filter was inoperative, creating significant visual artifacting in nighttime conditions. The prosecutor stands. Objection relevance. The judge looks at the defense attorney. Where are you going with this, counselor? Credibility and perception, Your Honor. The judge waves a hand. I'll allow it. For now. Answer the question, officer. The officer shifts in his seat. I was not aware of that specific technical issue, no. The lawyer gives a slight, almost imperceptible nod. The first seed of doubt has been planted. Not about the taillight, but about the very tool used to record the event. The lawyer is subtly suggesting that the officer's perception might be as faulty as his equipment. So, without a reliable video record, the lawyer continues, we are relying solely on your memory of the event, and of course your report, which you've testified is accurate. Yes, my report is accurate. This is the anchor the officer clings to. In the chaotic world of policing, the report is scripture. It's what transforms a fleeting, high-stress encounter into a permanent, official record. Officers are trained to live and die by their reports on the witness stand. And every skilled defense attorney knows it. In that report, officer, you state that as you approached the vehicle, you detected, and I quote, a strong and overwhelming odor of burnt marijuana emanating from the passenger compartment. That's correct. And this odor is what gave you the probable cause to ask my client to step out of the vehicle and to subsequently conduct a search, correct? Yes. The trap is being set, piece by meticulous piece. The jury is leaning in. This is no longer about a broken taillight. It's about a fundamental constitutional protection against unreasonable searches. Officer, how many marijuana-related arrests have you made in your 7-year career? The officer thinks for a moment. I couldn't give you an exact number. Hundreds. Hundreds. The lawyer repeats, letting the word echo. So you are very familiar with the smell of burnt marijuana? Yes. Very. Would you say your sense of smell is a crucial tool in your line of work? It can be, yes. The lawyer walks over to the evidence table and, after a nod from the clerk, picks up a clear plastic bag. Inside is a small electronically sealed vape pen. Officer, this is People's Exhibit B. The vape pen found in my client's center console. The lab report, which the prosecution has already entered into evidence, confirms it contains a legal, commercially available CBD oil with the pine scent. It contains 0D. It is not marijuana. Is this the item you believed was the source of the overwhelming odor of burnt marijuana? The officer eyes the exhibit. At the time, based on the smell, I believed it was marijuana, yes. Despite the fact that it is a legal substance that is not marijuana and, according to the lab, produces a vapor that smells of pine, not burnt cannabis? The prosecutor objects again. Argumentative. Sustained, the judge says. Rephrase, counselor. The lawyer doesn't miss a beat. Officer, did you find any other substances in the car? Any burnt cigarettes, any pipes, any bongs, any actual physical marijuana? No. So the sole source of this overwhelming odor was an item that we now know, for a scientific fact, was not marijuana? The officer hesitates. It's what I smelled at the time. The lawyer turns to face the jury for a brief moment. He's not telling them the officer is a liar. He's showing them. He's letting them connect the dots themselves. The officer isn't malevolent, he's just wrong. And if he was so profoundly wrong about the very thing that justified the search, what else was he wrong about? This is the core of the defense. It's not about proving innocence, it's about manufacturing doubt. The lawyer's role is to find the single loose thread in the prosecutor's tapestry and pull, and keep pulling, until the entire narrative unravels. Now he moves to the next thread. Let's talk about what happened after you searched the car. You found a backpack in the trunk. Is that right? Yes. And inside that backpack, you found the items that led to the felony charges my client is facing today. Correct. Officer, your report states that my client gave you consent to search that backpack. He did. Tell the jury exactly what you said to him. The officer clears his throat, reciting from memory. I asked, do you mind if I take a look in this bag? And what did my client say? He said, go ahead. The lawyer pauses again, letting the officer's words settle. Officer, Are you aware that your department's body camera policy requires you to have your camera activated during any and all searches of a citizen's property? Yes, I am. And your body camera was on and recording during this part of the interaction, wasn't it? Yes, it was. The lawyer walks back to his table. Your Honor, I'd like to play a 30-second clip from the officer's body camera footage, already admitted as Defense Exhibit 4. The screen flickers on. The jury sees the shaky, first-person view of the officer opening the trunk. They hear the officer's voice clear as day say, "I'm just going to take a look in this bag, okay?" But then there's the defendant's response. It's not go ahead. It's garbled. It's indistinct. It's partially obscured by a passing truck. It sounds more like a mumble than a clear consent. The lawyer stops the video. The courtroom is silent. "Officer," the lawyer says, his voice now like ice, "you testified under oath that my client said, 'Go ahead.' But the video your own department's recording shows that his response was, at best, unintelligible. Isn't it true, officer, that you didn't have clear, unambiguous consent to search that bag? Isn't it true that you heard what you wanted to hear?" The officer is now visibly flustered. His anchor, the report, has been smashed against the rocks of objective reality. He can't claim the report is accurate, because the video contradicts it. He can't claim his memory is perfect because he just testified to something the video disproves. He's trapped. The sound on the camera isn't always clear, he stammers. "It was noisy. But you were certain enough to write 'Go ahead' in your official report? Certain enough to testify to it under oath today? You were certain about the overwhelming smell of marijuana from a legal CBD pen, and you were certain about the verbal consent that the video fails to capture. Officer, is it possible your certainty is misplaced?" The cross-examination has done its job. The officer, once the confident narrator of the state's case, is now an unreliable witness. His investigation, once presented as a textbook example of good police work, now looks like a cascade of errors in judgment, perception, and procedure. The prosecutor will have a chance on redirect to try and salvage his witness, to ask questions that explain away the inconsistencies. "Officer, have you found that body camera audio is often affected by road noise? In your experience, can different CBD products have different odors?" It's a desperate attempt at damage control, trying to put the pieces of their shattered case back together. But the damage is done. The jury has seen behind the curtain. They've seen how a simple traffic stop can be built on a foundation of shaky assumptions. The defense lawyer has transformed the state's star witness from an asset into a liability. The officer leaves the stand, his testimony a minefield of doubt. The foundation of the prosecution's case is now fractured, and the defense hasn't even begun to present its own evidence. They simply held up a mirror to the state's case and forced the jury to see all of its flaws. Now the courtroom holds its breath. The prosecutor, looking somewhat deflated, utters the words, "The state rests." The spotlight swivels. It's the defense's turn to take the stage. And this is a critical, often misunderstood, phase of the trial. For weeks, the lawyer's job was that of a demolition expert, meticulously placing charges to weaken the prosecution's structure. Now their role transforms. They must become an architect building a new structure in its place. A structure of innocence, or at the very least, a structure of unshakable, reasonable doubt. The defense doesn't legally have to prove anything. The burden of proof always rests with the state. They could simply rest their case right now, arguing that the prosecution failed to meet its burden. But a great lawyer knows that a jury craves a story. Leaving a vacuum allows the jury to fill it with their own speculation. So the lawyer must offer them a better story. A more plausible narrative that explains the evidence in a way that points away from their client. In our hypothetical case of the stolen corporate documents, the prosecution's story was simple. Greed. A disgruntled employee stole secrets to sell to a competitor. The defense lawyer now begins to tell a different story. Not a story of a thief, but a story of a whistleblower. They call a series of witnesses. A colleague who overheard the defendant arguing with his boss about unethical accounting practices. An email is introduced, one the police investigators saw but dismissed, where the defendant warns a senior manager that the company is misleading shareholders. Suddenly, the defendant's actions are recontextualized. Taking those documents wasn't an act of theft, it was an act of preservation. He wasn't stealing to sell. He was gathering evidence to expose a crime far greater than the one he's accused of. The lawyer isn't just denying the prosecution's facts. They are reframing the entire moral landscape of the case. But the masterstroke is yet to come. The lawyer calls their star witness. Not a friend of the defendant, not a family member, but a retired police captain. A man with 30 years on the force, a decorated detective who now works as a private consultant, an expert in police procedure and evidence handling. He takes the stand, his presence alone commanding respect. He is the embodiment of good policing. The defense lawyer walks him through the prosecution's entire investigation, piece by piece. "Captain," the lawyer asks, "what is the standard procedure for documenting a chain of custody for digital evidence, like a thumb drive?" The captain explains the meticulous process. Sealed bags, detailed logs, signatures at every transfer. The lawyer then produces the evidence log for the thumb drive found in the defendant's desk. Does this log meet that standard? The captain examines it. "No," he says calmly. "It's incomplete. There are hours, even days, unaccounted for. We have no way of knowing who had access to this drive, or if its contents were altered." The lawyer moves on. "Captain, in an investigation involving potential corporate espionage, would it be standard practice to secure the computers of the executives who were accusing the defendant?" "Absolutely," the captain replies. "You have to preserve all potential evidence. The accuser's communications are just as important as the accused." The lawyer turns to the jury. "And was that done here?" he asks, already knowing the answer from the lead detective's earlier testimony. "Based on the reports I've reviewed," the captain says, "it appears it was not." One by one, the lawyer uses this unimpeachable police expert to dismantle the official investigation. The sloppy note-taking, the failure to interview key witnesses, the singular focus on their client from the very beginning. This isn't just creating doubt anymore. This is painting a picture of a bungled, biased investigation. The lawyer is leveraging the police's own high standards against the shortcuts taken in this specific case. It's a brilliant move. The jury is now hearing from a cop that the cops on this case didn't do their jobs correctly. The police versus lawyer dynamic has become good police versus bad police, with the lawyer as the one bringing the truth to light. With their narrative established, the defense rests. The stage is now set for the final performance. The closing arguments. This is the culmination of everything. It is the last time the lawyers will speak to the jury. It is their final chance to weave every thread of testimony, every piece of evidence, every moment of doubt into a single, cohesive, and persuasive tapestry. The prosecutor goes first, trying to repair the damage. They try to rebuild the credibility of their detective, framing him as a hard-working officer doing his best against a deceptive criminal. They portray the defense's whistleblower story as a desperate, last-minute fabrication, a fantasy cooked up to excuse a simple act of greed. They hold up the documents, reminding the jury of the core of the case. "Don't get lost in the weeds of procedure," they plead. "Don't let a clever lawyer's smoke and mirrors distract you from the simple truth." Then the defense lawyer rises and walks towards the jury box. They don't begin with anger or aggression, but with a quiet, deliberate tone. "For the past 2 weeks," they begin, "the prosecution has asked you to build a bridge of guilt, leading from the evidence they presented to a conviction for my client. But a bridge must be built on a solid foundation, with every piece fitting perfectly. If there are cracks, if there are gaps, if the foundation itself is unstable, that bridge will collapse. And your sacred duty as jurors is not to try and patch those cracks. It is to refuse to cross." The lawyer then walks the jury back through the trial, not as a collection of facts, but as a series of unanswered questions. "They told you the lead detective was a seasoned professional, but we learned his notes were so incomplete, he couldn't even remember who he spoke to on the day of the arrest. Is that a solid foundation? They showed you a thumb drive they claim is the smoking gun, but their own expert, a police captain, told you the chain of custody was so broken we have no idea what's really on it or who put it there. Is that a piece that fits? The prosecution tells you my client's motive was greed, but they never showed you a single piece of evidence that he ever contacted a competitor. Not an email, not a phone call, not a text message. They want you to fill in that gap with your imagination. But you swore an oath to judge this case on the evidence, not on imagination." The lawyer's voice builds in intensity. "The state's entire case rests on the idea that you should trust the conclusions of an investigation that was, by the admission of a veteran police officer, fundamentally flawed. They rushed to judgment. They developed tunnel vision, focusing only on my client and ignoring evidence that pointed in another direction. Evidence of serious wrongdoing within the company that my client was trying to expose. The prosecutor called our defense a fantasy. But what is more fantastic? That a man would risk his career to expose corruption? Or that a professional police investigation would be this full of holes, this riddled with doubt? The state has not built you a bridge. They have given you a few scattered stones and a flimsy rope and asked you to leap across the canyon of doubt. The Constitution, the very principle of our justice system, forbids you from making that leap. The lawyer pauses, making eye contact with each juror. The judge will tell you that you must find my client guilty beyond a reasonable doubt. That is the highest standard in our law. It is not he probably did it or he might have done it. It is a certainty, an abiding conviction. After hearing about the flawed notes, the broken chain of custody, the uninterviewed witnesses, and the ignored evidence, can any of you truly say you are certain? Can you say you have no reasonable doubt? If you cannot, if a single nagging question remains, then your duty is clear. The lawyer returns to the defense table and sits. The silence in the courtroom is absolute. The two stories have been told. The police and prosecutor's story of a simple crime, and the lawyer's story of a flawed investigation and a greater injustice. The battle of narratives is over. Now the power shifts one last time, from the police who investigated, to the lawyers who argued, to the 12 men and women in the jury box who will become the ultimate arbiters of the truth. Behind a closed door, in a sterile, windowless room, the real trial begins. Here there are no lawyers to object, no judge to sustain, no police officers to testify. There is only the evidence, the instructions from the judge, and the collective conscience of 12 ordinary citizens tasked with an extraordinary responsibility. They are handed the chaotic, contradictory fragments of a human story, and told to assemble it into a single definitive picture of truth. Every piece of evidence the police gathered, from the dusted fingerprint to the grainy surveillance footage, is laid bare. Every argument the lawyers made, every doubt they raised, every emotional plea they delivered, echoes in the silence of that room. This is the crucible where the two versions of truth are melted down. The police's truth, built on investigation, observation, and the pursuit of a suspect, is a narrative of cause and effect. They believe they know what happened, and they've spent months building a case to prove it. The lawyer's truth, built on the rules of evidence, the presumption of innocence, and the protection of rights, is a narrative of legal scrutiny. They aren't necessarily arguing for innocence. They are arguing that the state has failed to meet its sacred, constitutional burden of proof. The jury must now decide which truth prevails. Is there proof beyond a reasonable doubt? Not a shadow of a doubt, not all doubt, but a reasonable one. It's a deliberately ambiguous standard, a threshold that relies entirely on human judgment. Hours, sometimes days, pass. Voices rise and fall. People who were strangers just weeks ago now engage in one of the most intimate and consequential conversations of their lives. They debate the credibility of the officer on the stand. Did he seem confident because he was telling the truth, or was it arrogance? They scrutinize the defense lawyer's closing argument. Was it a brilliant deconstruction of a weak case, or a clever misdirection? A smokescreen to hide a client's guilt? They weigh the physical evidence against the human testimony, searching for the point where the story holds together or the moment it falls apart. Then a decision is made. A note is passed to the bailiff. The jury files back into the courtroom, their faces unreadable, a collection of stone masks. The air in the room becomes thick, heavy, impossible to breathe. The defendant stands, hands trembling or clasped tight. The police officers who made the arrest sit in the gallery, their own careers and convictions on the line. The lawyers, prosecution, and defense stand rigid, their work now utterly out of their hands. The finality of this moment is absolute. The foreperson hands the verdict form to the clerk, who passes it to the judge. The rustle of that single sheet of paper is the loudest sound in the world. The judge reads it, their expression betraying nothing, and hands it back. In the matter of the state versus the defendant, on the charge of the crime, we the jury find the defendant guilty. A wave of reactions ripples through the room. A quiet sob from the defendant's family. A deep, relieved exhale from the lead detective. The prosecutor gives a solemn nod to their team. The system in their eyes has worked. The long hours, the frustrating dead ends, the meticulous collection of evidence, it was all validated. The truth they uncovered has been affirmed. The defense lawyer places a hand on their client's shoulder, a gesture of finality and grim acceptance. Their fight is over. They forced the state to prove its case. They held the police accountable for every step. They gave their client a voice. They lost the battle, but they fulfilled their sworn duty to the process. Justice for the victim and for society appears to have been served. Or, not guilty. The words hang in the air, a shockwave of disbelief. The defendant stumbles, a gasp of air returning to their lungs as the weight of the state is lifted from their shoulders. The defense lawyer claps them on the back, a wide grin of triumph and relief breaking across their face. They have done the impossible. They stared down the full power of the government and won. They exposed the reasonable doubt, the holes in the police work, the constitutional overstep. They protected their client, and in doing so, they protected the principle that accusation is not proof. Across the aisle, the police officers are stunned, their faces hardening with frustration and anger. They see a guilty person walking free. They see their hard work dismissed, their expertise questioned, their pursuit of justice thwarted by what they perceive as legal gamesmanship. In their minds, a failure has occurred. A dangerous person is back on the streets, and the system, the very one they serve, has let them down. So which is it? Is this system a well-oiled machine for finding truth, or a broken-down relic that lets the guilty escape? The answer is that it's neither. And it's both. The tension you feel, the ambiguity of these two outcomes, isn't a flaw in the system. It is the system's central defining feature. We have built a justice system that is intentionally adversarial. It is designed to be a fight. We give the police immense power, the power to investigate, to detain, to accuse, to use force. This power is necessary to maintain order and protect society. But unchecked power is the definition of tyranny. And so we created an equal and opposite force: the defense lawyer. Their job is not to be friends with the police. Their job is not to make the prosecutor's life easy. Their job is to challenge, to question, to doubt, and to fight back against the state with every legal tool at their disposal. The police officer's goal is to close the case. The lawyer's goal is to protect their client. These two objectives are fundamentally and purposefully at odds. The police push and the lawyer pulls. The police build a case, and the lawyer tries to tear it down. It is in this violent collision, this crucible of conflict, that we hope the truth is revealed. We believe that a case strong enough to withstand the most rigorous, skeptical, and relentless attack is a case we can trust. It's a process of purification by fire. This is why understanding the distinct roles of police and lawyers is so critical. We often want to cast them in a simple morality play: the good cop versus the sleazy lawyer, or the corrupt cop versus the heroic public defender. But reality is far more complex. The vast majority of police officers are driven by a genuine desire to get the bad guys and protect the innocent. The vast majority of lawyers, both prosecutors and defenders, are driven by a commitment to their role within the legal system. The problem is that these roles force them into conflict. A good cop, suffering from tunnel vision after a horrific crime, might unconsciously ignore evidence that points away from their chosen suspect. They're not necessarily corrupt, they're human. They believe they have their man, and their focus narrows. It is the defense lawyer's job, their duty, to attack that tunnel vision, to force the court to look at the evidence that was ignored, to present the alternative theory. Conversely, a defense lawyer knows their client is factually guilty, but they also see that the police violated their client's Fourth Amendment rights with an illegal search to find the key piece of evidence. The lawyer's duty is not to judge their client's morality. Their duty is to uphold the Constitution. They file a motion to suppress the evidence. If they win, a guilty person may go free. This outcome feels unjust to many, especially the police. But the lawyer's victory isn't just for their client. It's a message sent to every police officer. Follow the rules, respect the Constitution, or the case you build will crumble. So check on power. This system is not about making everyone happy. It's about creating a balance between two essential societal needs: the need for order, represented by the police, and the need for liberty, represented by the lawyer. We need police to investigate crimes and keep us safe. But we also need the guarantee that if the state ever turns its powerful gaze upon us, there will be a zealous advocate standing by our side, ensuring that our rights are not trampled in the rush to get a conviction. The police and the lawyer are not just adversaries. They are the two pillars that hold up the arch of American justice. If either one is weak, the entire structure becomes unstable. If the police are allowed to be sloppy, corrupt, or ignore the rules, innocent people will be convicted. If defense lawyers are ineffective, underfunded, or don't challenge the state's case, the presumption of innocence becomes a meaningless phrase. In a strange, unspoken way, they make each other better. A police department that knows every piece of its evidence will be scrutinized by a skilled defense attorney has a powerful incentive to conduct more thorough, careful, and constitutional investigations. A defense attorney who is up against a meticulously prepared case by honest, diligent police officers has to be smarter, more prepared, and more creative. They are locked in an eternal struggle, but that struggle sharpens them both. The ultimate truth of our justice system is that it is a deeply human enterprise. It is messy, imperfect, and often unsatisfying. It is administered by police officers and lawyers who bring their own biases, strengths, and flaws to the table every single day. But it is built on a profound and enduring idea that the best way to find something resembling truth is to allow two opposing sides to fight it out, under a strict set of rules, before a jury of our peers. Justice isn't a destination we arrive at. It is the process itself, that tense, difficult, and necessary negotiation between accusation and doubt, between the power of the state and the rights of the individual. And at the very center of it all stand the officer and the lawyer, not as hero and villain, but as the two essential, opposing forces that hold the entire structure in balance.